Good afternoon, ladies and gentlemen. Welcome to this panel discussion. We are discussing about the latest developments in the law of arbitration. And as always, I'm very happy to see that everybody is enjoying this conference, because MCI conferences are very exciting always. I'm glad to be here and thank MCI Madhvendra and Nidhi for this opportunity. I also thank my panelists for being available, and also want to acknowledge the presence of distinguished guests in the audience. And this is a good opportunity actually. This is an annual event of MCI and gives a good opportunity for people to stay up to date, get good insights and perspectives about the law of arbitration, and also to connect with people, build their relationships, and in a way to stay ahead of the competition actually. So I'm very happy to see that there are a lot of participants who have actually returned back after lunch for this session as well. So with this panel, we are going to talk about a very interesting subject of cross-examination, but in an online format. And in fact, when I was discussing this with my panelists, I actually feel that I should have been sitting in the center because there are different views, so I could have balanced them. But now they're all on the one side. We're going to talk a little bit about the group of companies doctrine and how do you impede a third party, and of course also the enforceability of arbitral awards against the non-signatories. An interesting topic about the enforcement of emergency awards, both for the domestic and foreign seated arbitrations. And if time permits, we will also cover the consolidation of arbitrations in ad hoc as well as institutional arbitrations, and then amendments that have been brought about in Section 36. So those are the things that you could look forward to with this panel discussion. So I would like to start with the very favorite subject, which is about cross-examination. I mean, as a litigating lawyers, they want, as I see, there is a widening gulf between the lovers and haters of cross-examination online. The whole arbitration, online arbitration itself, I see that COVID-19 pandemic actually brought in a good interest for people to do online arbitrations. But as the pandemic has declined, I again see that people have that appetite for going back to physical arbitrations. But like MCI has also published that 80% of the arbitrations have been end-to-end online. That's a very good, I would say, development, and we should all promote online arbitrations, because ultimately who's paying for it? The parties. If the parties have the cost and time efficiencies, then why not? We should all play the ball. But having said that, we have the panelists who I would like to know from them what is their perspective about it. If you ask me honestly, the cross-examination is like a game of treasure hunt. You've got to get to the treasure, that is the truth, no matter how you get to it. But certain lawyers who might feel that, no, I would like to read the body language and then actually get to my next question, that how do I put my next question, put him to the corner and try to discredit the witness that he is lying. So having said that, setting the context right, I would like to ask Rajat first, what does he feel about online cross-examinations?
Thank you, Madhvendra. So I'm told in a minority, because I am somebody who's loved my experience when it comes to conducting cross-examinations online, but I believe I'm in good company. And Nidhi, Madhvendra, thank you for being on our side. I think cross-examination has never been as effective, as efficient as it now is. And you mentioned body language. I must take this for the record that body language, in fact, when it came to cross-examination before Indian courts, for example, was never a consideration at all. Because cross-examinations would go on for donkey years. And judges would change. You would go and do your cross-examination before one judge. That same witness, the next date will come after 6 months, another judge would be looking at it. Even when it came to arbitrations, you were sitting in a room full of 20 people, 10 this side, 10 the other side, and there were 3 arbitrators. Everyone sipping coffee, somebody dropping a pencil. The focus continued to waver. But when you're on a screen, And now that your witness is in front of you and everyone's focus is almost entirely on the screen, hopefully nobody is texting during that cross-examination. But if your focus is on the screen, the moment that person even flinches, the body language is noticed by the arbitrators. So I don't think it has ever been as efficient as it is now. It gets completed within 2.5 hours, 3 hours, 4 hours, because there are fewer distractions. There are only so many questions that you can ask. I mean, I don't understand the other side maybe. I was on the other side, but now I can say comfortably that I don't probably understand the objections from the other side, because a cross-examination is not a police investigation. Yeah, you don't need to necessarily be in the same room, sort of threaten the witness and make that person crack. It's a line of questioning. Finally, you can get to where you want. Thank you. I'll pass my call to whoever is next.
So is it good for the lawyers to intimidate their witnesses in physical examinations? Is he allowed? Does he have the right to privacy when he's behind the camera, or is it allowed to be coached while he's doing it? So in my arbitrations, I have seen that. In fact, that actually brings me to the question of doing a real-time transcription or allowing a steno to be there, because real-time transcription, even if you cough out, it will get recorded, and then you can't go back into it. Whereas I have seen as a practice, like you're doing a cross, you allow. It's not a test of his memory actually. That's what we say. And then you're allowed to go back to your answer. And before you actually record it, you tell him that, are you sure that you want to stick with his answer? Because he would have said a yes to a particular question, but he wants to change it to no. If you allowed it, don't allow it. So I'd like actually go to Nitin. Nitin, do we as lawyers do also act as psychoanalysts, check their body language, say that he's lying, or should we take them to task? What do you think? We should do it online, don't do it?
So, to answer this, there are two parties to a cross. One, the person who is being crossed, and second, the person who is crossing. So the question is that how comfortable over last 2 years are we advocates to actually argue and cross on an online platform itself. So that would be the first point. Like Rajat said that he is very comfortable. I am not. A. B. I would put it in the way that what kind of cross you are doing. If I am just coming with checking of factual accuracy, just trying to get some facts out of him to collaborate already what is in document, probably yes, online is uncomfortable. But as generally it is, if I am wanting to destroy the credibility of the witness or bringing out something in contradiction to what he has already testified, maybe on affidavit or something, then the very fact that the body language, his attention which I can draw in physical mode is so very important. Third, you must not forget that as an advocate, you are used to that arbitration room or courtroom, but the witness is not. So the very fact that the witness is out of his comfort zone and being part of a situation where as an advocate you are more comfortable than him will actually be able to make him falter and, as they say, bring out the truth, or bring out the truth which I believe is the truth, to be very honest about it. So therefore, in my view, the physical, still today as a lawyers, we have not trained ourselves to as effectively cross in terms of what we do in physically. Plus, what is the control which I have as a lawyer while crossing? Documents to be shown. It will take time for it to be shown or handed over while I'm crossing it to the other side in the room. Second, obviously, is a very, very important aspect is giving him time, that time lag which is not there in physical, while it is there in virtual, may immediately enable him to actually change his question before I immediately stop and make him go to a next question and just have a kind of a leading questions. So in a leading question where my entire purpose is to lead the witness to a particular thing. I just don't want him to say anything more than yes or no, or probably make him commit on a particular aspect. So those aspects I believe is very difficult to achieve in a virtual world.
So great. I mean, like they say, right, cross-examination is not just an art, but it's also a science. But also that brings me to one point is that do we have common understanding about how to do online cross-examinations? Because certain institutions like CIM and IPS, they have come up with the guidelines that how the online dispute resolution will be conducted and even including the cross. But also, let's say if the parties have agreed in an arbitration agreement, they would do end-to-end arbitration online, including the cross. Or otherwise, let's say parties are not agreed, but the tribunal insists that they will do a cross online. Can it be a fertile ground for challenge for that award subsequently given to that? Amitava, what do you think about it?
Hi. I think we need to move with time. I think the COVID period has shown us using the screen as being an alternative of having physical hearings. I've heard a lot about MCI doing online hearings, and I do a lot of shipping matters where actually there is no evidence required at all, because it is agreed between the parties that it will be on documents only. We are in arbitration, we are not before the court. If we wanted to have a detailed CPC application, then we would go and file a suit. Why agree to arbitration? We need to minimize those formalities, and we've seen, at least in shipping, that without evidence, leaving it to the tribunal, who are experts in the field, matters are expedited and completed much faster. But if I were to have a cross-examination, I would imagine that it is cost-effective, which is what your client wants, to do it virtually. I have maybe wanted to do a cross with someone who's in Ghana or in Sierra Leone or in US, who I would put into a lot of trouble to come down, having agreed to arbitration, which is supposed to be cost-effective, to come all the way down to India just to be crossed, when everyone can get online. And all you need to do is, as correctly put by Madhvendra, to have rules which would be followed, guidelines. So for example, me having someone sitting in US from my side with a clean set of papers which would be given to the witness, so that the same exercise can be done. I think the future lies in trying to consolidate these issues to make it more expeditious and more easy for the client. Now, if parties agree, I don't think there can be any challenge to that at all. But if the tribunal insists, at the end of the day, according to me, the tribunal decides on the procedure. So it would be difficult unless it can be shown why virtually it could not be done, why it had to be done virtually, that such an award would be set aside.
Yes, sure.
I'll just add to that, while we have views on hating and loving online and offline cross-examination, from an in-house perspective as a client, what we would appreciate is, of course, what is cost-effective, time-effective for us as well. We definitely want to have, everybody wants to have the award in their favor, but that's not how it always goes. However, having said that, it is important, and I think it will eventually, with time, COVID has taught us a lot. We will come to a point where we will have these SOPs by institutional arbitrations, where they will list down the SOP for online cross-examination, but physical has its own benefit, as Rajat and Nitin have pointed out, and that does make an impact when you're out of your comfort zone, when the witness is out of his comfort zone. I've just recently experienced that as well in a few of my arbitrations ongoing. So maybe once the SOPs are in place, that will really help, but it has to be kept in mind, keeping the perspective of the clients also, because the person getting examined and the person examining are important, but ultimately there's a larger picture involved in that, that's of the clients, so that also has to be taken into consideration.
Sure. In fact, Amitava, when you talked about the maritime arbitration, for the benefit of the audience, I just want to bring out three aspects of maritime arbitration which stand out. One is, of course, easy consolidation of arbitral matters, even if they're not connected with the same arbitration agreement. Second is they allow for the documents only arbitration. 80% of maritime arbitrations are document only. Parties don't even appear. Lawyers don't appear. In fact, morning you would have had a session on the artificial intelligence. Trade lanes went ahead to the extent of doing end-to-end arbitrations on blockchain. And Claros was then interfaced. Claros has their digital arbitrators who would earn their credit points, and physical arbitrators could also pitch in if they had their credit points. And the complete arbitrations were resolved and the parties didn't even get to know about it. Ultimately, the awards were issued. And of course, another thing was that the maritime arbitrations are seeing most and more commercial arbitrators being appointed who get right to the fact of the matter. So with that, just one question I want to ask Rajat is that, Rajat, in case parties have not agreed in the arbitration agreement for an online arbitration, but tribunal insists that we do cross, including the cross, we do complete arbitration online, can that be a ground for challenge?
I would see the procedure and the manner in which the arbitration is to be conducted, in the first place, is to be decided by the parties. And very often, which is why we have procedural orders at the very beginning of an arbitration, where either the parties sign off on the procedure that the arbitrator proposes, or in the alternate, the arbitrator sets down by way of a procedural order the manner in which the arbitration will be conducted. Now that could be, certain parts could be online, certain parts could be offline, it could be hybrid, it could all be online, all be offline, but well, all these issues I think get resolved in the very beginning itself. Now there obviously can be situations, for example when COVID hit, there were multiple arbitrations which were ongoing and decisions had to be taken. There were only two alternatives. Either you let the arbitrations go for what initially appeared to be 3 weeks, then 3 months, then finally effectively 2.5 years. Don't act at all. Or the other alternative was what was more prudent for businesses. That let's all get together, let's attempt it. I mean, at the end of the day, I'll tell you something, a very interesting issue. Most of these business decisions by these big business entities are taken by boards which are not located in one single place. So you will, for example, a Coca-Cola board will have 2 people in America, somebody in Japan, 1 person in Australia. If the business decisions can be made online, and Cisco and Zoom are not something which were born from the pandemic. They were being utilized throughout the business industry forever. I mean, during many discussions, I've had this, discussion about data protection. I mean, data protection is an issue in general. Data protection is an issue which is not specific to litigation or arbitration or dispute resolution. Now, once we rise over all of this and we look at only effectiveness of the procedure, I don't think I don't think any court will be willing to entertain a challenge to an arbitration which went online because there was no option, or when both parties agreed, or even otherwise. For example, when the arbitrator dictated at the very beginning what the procedure for conducting the arbitration shall be.
Great. I again get to just putting a point.
Balancing view, yeah.
So somehow we are sitting close, but then we are contradicting in terms of the views. See, I believe the challenge would be on the relevancy of the evidence which would have come out of the cross. If it is simply a formal kind of a fact finding which otherwise you could actually show it from the document, then no court will entertain it. But if suppose for example it's a fraud, I'm crossing someone to prove that there is a fraud, can't possibly take my right of, as they say, to take away from a party who will have an advantage of the physical cross of a person to prove a fraud. So in that case, the relevancy increases and maybe some good lawyer will be able to persuade to the court to interfere.
Well, we'll wait for the statistics to come out from the institutions. But to me, it looks very optimistic that people are getting used to doing it online. As far as the parties' concerns are concerned, that is time and cost, if you can benefit the parties, why not? So that actually brings me to a very valid point you said, is that party autonomy is a cornerstone of arbitration. And like Supreme Court said, it's a brooding and guiding spirit of arbitration. If the party consent, in this case probably it is conflicting with the competence of the tribunal. But notwithstanding, with respect to the party autonomy, enforcing of arbitral awards against the non-signatories, that is something which is very critical, and the law has been changing. The courts have had different stands on this. What we see is that the exceptions are there. There is the doctrine of the group of companies, and also as long as the companies or the entities are a single economic entity, or the third party has willingly participated in the arbitral proceedings, having implied given consent or a waiver. So in that thing, and also how do you implead a third party to such an arbitration where they are a non-signatory to the arbitration agreement? So let me start with Nitin. Nitin, what do you think? First, how do you implead a third party like that? And then how do you enforce arbitral awards against such parties?
So the question is, how do I implead? There are two ways one can implead. One, a third party itself would want to get impleaded. Then the only option available to it is to file an impleadment application saying that this award will affect me and therefore implead me. On the other side, if already the parties to an arbitration wishes to include or implead a third party, again a formal application is required, and which will have to be decided by the court. The question I'll leave for a different debate, or maybe next time, that under which section of the act would we want to file an impleadment application. But third party, I would just categorize the third party as in 2-3 buckets. The first bucket is a third party who is signatory to a multilateral agreement, multi-party agreement, but at the same time he is not a disputing party. I hope everyone, so there are 3 parties who have entered into an agreement. 2 of them have a dispute with each other. So according to me, the third party, which is not a disputing party, A and B have dispute, C is not a disputing party. So according to me, even if he is a signatory, he will be a third party to that litigation, to that arbitration which has been initiated. So one is this. Second is rank non-signatory. If a rank non-signatory is there, then obviously the exception, as rightly pointed out by you, is whether it's a group company concept will come into play, whether the arbitration award will fall into futility if not, and our age-old principle of necessary and proper party, which though CPC as such formally may not be applicable, but obviously the principles will be applicable. So according to me, impleadment of a third party will be guided by the age-old principle of proper and necessary party, which will have to be shown by the applicant with respect to the third party. Plus, also while deciding that, or while putting your grounds on that, one will have to connect the dots between the party to the litigation and the third party in terms of their relationship, in terms of being affected, in terms of necessity. All those dots will have to be connected. So, my initial remarks would be to this extent. There are judgments to that effect.
So that actually, what are the 2 fundamental principles when you look at bringing a third party, as non-signatory third party into arbitration? It actually emerges from the Indian Contracts Act and the International Commercial Law, which talks about first is the privity of contract, whether he is benefiting from that contract or not. So having said that, do you think, even in the Supreme Court, I think one of the matters was the Jalan, section 46, they have interpreted to say that it says persons as between whom it was made, which is a wider term just to use parties. So that means they have allowed third parties, non-signatories, to be party to the arbitral awards. Enforcing arbitral awards against third parties. So Rajat, tell me, one is how do you implead, and then how do you enforce such awards against the non-signatories? In the light of the judgments that Supreme Court has given.
Yeah, I think this
and also, I just request my panelists to be very crisp because we're running out of time already.
Yeah, I think this is an extraordinarily complex issue because there are 2 sides of how a party is to be implemented. One is there is obviously somebody moving an application or that party moving an application asking to be implemented. At the same time, there may be instances where somebody's, according to me, wrongly made a respondent or party to the proceeding. In which case, how do I move an application to ensure that they're deleted? Now, where do we find the basis for this? Anywhere in the Act, and I can't find that basis. Will it then fall into probably the residuary provision section 16? Will it then be a jurisdictional issue which will have to be decided at the outset? Or will we have to make that distinction, classic distinction under CPC where Order 1 Rule 10 is not a jurisdictional issue like 710. It is only where a plaint is to be returned. If somebody is not added correctly or you fail to make a necessary or a proper party, a party to that.
Are the tribunals going ahead and doing that?
Sorry?
Are the tribunals?
So, Section 16 unfortunately reads in a manner that even though the person moving the application has to do it before they file the defense, but then the word used when it comes to exercising of jurisdiction by the tribunal, the word is may. So very often the tribunals just simply make it a preliminary issue to be decided at the time that they render the award. So I don't know where to exactly fit this in, but I think probably Section 16 is one of the ways to look at it.
I would like to go to Amitabh now. In fact, let's talk about the group of doctrines thing also, where the Supreme Court has actually brought out the factors for consideration, including the mutual intent, the relationship with the signatory, commodity of subject matter, composite nature of the transaction, and the performance of the contract. So it's not a simple answer to say yes or no, because there's a complex corporate structure that needs to be understood before you give a decision. And whether, like I said, whether somebody who is connected to the contract or not connected, non-signatory, does he benefit from the execution of that contract, being the underlying principle? So Amita, what do you think? Let's leave the impeding part of it now, but can we talk about the enforcement of such arbitral awards?
So, according to me, when they talk about third party being impeded or so, this comes out through the wording of the section through and under, and that was what came up for consideration before the Supreme Court. I find that having anyone who may be related to be made a third party is dangerous. It violates the concept of lifting of the corporate veil, the corporate structure, and therefore one has to be very, very careful when going into this. We work in a field, for example, in shipping, where we work on SPVs holding one ship, one company. Each of those 10 companies may be owned by another company, which is then owned by a group company. Now, if there's been no fraud which has been played, there is no right for anyone to just say, well, all these ships, all these companies which have more assets are part of the group company. They should all form part of the arbitration so that I can enforce the arbitration award against them. I think one needs to be very careful when treading on those. According to me, through and under comes into play, or these third party, for at least in my line of practice, would come into play for situations where a promoter who is standing as a guarantor for the SPV and has entered into the contract on behalf of the SPV saying that we will guarantee the performance, but has not signed it as the company. There, I think there is a scope of saying, well, just because you didn't sign it doesn't mean that you haven't said that you're a party, because you've guaranteed it. Now you can't hide behind the technicality of signature. That would be one of the cases where you would bring it in. Another case is where you have insurance companies, subrogates. Once you have paid out the debt, paid out the claim, you become subrogated. How do you come into the step of the actual claimant in the arbitration? You come through and under. In fact, this was one of the cases which was there a long time ago before the amendment, where the Bombay High Court passed a judgment saying an insurance company cannot come in and arbitrate because they don't come through and under. But now with the amendment having been made, they are entitled to be a party as well. And as you know, there's a difference between the assignment and subrogee. So therefore there is cases where you will have to have both the principal and the insurance company a party, and you may have to have them impeded. But I think that would be the limited role, unless you're able to show something more in the matter.
Sure. So that also brings me to the question of, like, a lot of parties now, because the Indian Arbitration Act does not really allow for in the basic understanding of an award, does not really cater for the emergency awards. So parties, Indian seated arbitrations, parties going abroad for institutional arbitrations, getting emergency awards, then trying to enforce in India under Section 9 to get the similar or some other interim award. So, Nidhi, what do you think? I mean, would you want to talk about this? Okay, Nitin, what are your views on this?
Yeah, just before this question, section 16 I had a very important point of view. The question is, implement application is to be filed under which section? Under section 16, the implement application, the scope is only authority and scope, if beyond. Then the courts have held that the implement order or order impleading a party is a procedural order. So it can never be a jurisdictional order. So to that extent, it will not lie under section 16. We'll have to find the fountainhead of it somewhere else, which I believe again is the general section 7 and the general principles, and the section 19, the general principles of CPC will be made applicable and the principles of impleading party will be made applicable. Second, in section 16, the question is that whether under subsection 1, the section 16 says that an arbitrator may decide upon the jurisdiction. Under 2 and 3 it says the party shall file an application within a particular period. Section 5 says that the arbitrator shall decide on it. And finally, section 6 says that if it is decided, what will be the recourse to the parties. According to me, if you file a section 16, the parties will definitely, the arbitrator will have to decide and he cannot postpone it to the end of the award, because the very section 5 interprets in a manner that it uses the word shall, and secondly it says that once you decide, thereafter you proceed with the arbitration proceeding. So it is mandatory for the arbitrator, in my view, to decide the application under section 16 first, and though implement application is according to me not forming part of section 16, but that also needs to be decided at the outset. Now in terms of
in fact, I've also seen this happening in arbitrations. In fact, in one of my applications, we had section 16 filed before the arbitrator. We filed it just after section 9 was filed, and the section clearly says that he may pass the order. Everybody here would agree with me that no arbitrator is going to pass it right when section 16 is filed and say that yes, I don't have the jurisdiction. That hasn't happened in my experience so far, and I'm sure everyone reckons with that as well. And I think it just leads to also multiplicity of proceedings and adding more, instead of making arbitration a time-saving mechanism, it adds more and more time, because once I have finished my hearing with you and then you say you don't have jurisdiction, it just takes more time away from me, which ultimately is again at the loss of the litigants also, and I don't know how much of that makes sense. It doesn't make sense. So either it should be passed right in the beginning, which again, everyone, all of us are humans, we have bias and prejudice. I don't know how will it work against the person filing the application if the arbitrator agrees or grants him that application in his favor, and how will it go? It's just adding to multiplicity. So a way has to be found where you do make it possible that it is passed before the hearing starts altogether.
Okay. So, Nitin. So, my question was that, of course,
emergency
award.
Just skip it. So, in emergency award, I think it's a fancy name given to a very simple thing which we all lawyers understand. It's an interim order. It's an ad interim order, to say the least. Though in emergency award, you have to first appoint your arbitrator, which is the judge, and then after hearing both the parties, it will be decided. So how we lawyers have been over the years filing a NM application or this an interim application is simply that. The question is whether under the Act, before appointing an arbitrator, where do you go and find that? So right over the period in Unicentral model in 2006, scope was extended for an arbitral tribunal to be considered as passing an arbitration award. Now, the recent judgment of Amazon, wherein the Supreme Court has allowed execution of an an emergency award, which Amazon was successful in having one under the SIAC rules, but with respect to a India-seated arbitration. So there the matter went to Supreme Court. Supreme Court said that since you are bound by the rules and procedure, and under the rules and procedure there is already a provision for emergency award, you are bound by that, and therefore Amazon's getting an emergency award was held to be correct under law. Now this brings to the issue as to the how and where is the emergency award which can be useful. So the very concept of institutional arbitration comes here. In ad hoc arbitrations, you cannot appoint a judge, and therefore there is no question of emergency arbitrators being appointed. It is only under institutional arbitration where the rules provide with respect to a kind of emergency award. You can probably approach that institutional arbitration, who can then appoint, and things can follow. The question does lie about the execution of such emergency award, where and how it would lie, and probably.
Yeah, so it's well settled in the case of Amazon and future retail. India-seated arbitration is fine, but Amitava, I would like to ask you, if this was a foreign-seated arbitration, and there are two scenarios. One is that party is successful getting a relief, and second situation is the party is unsuccessful in getting a relief. Under these circumstances, being a foreign-seated award, do you think that courts in India would be in favor of giving an interim relief under Section 9 or not?
But if you get a Section 9, if you get an interim or rather emergency award in a foreign-seated arbitration, Part 1 doesn't apply, actually Section 17 does not apply to foreign-seated arbitration. So the only sections that you can really rely on is Section 9. So you can use the emergency award which you've got as a prima facie case to make out. But I think the courts in India will obviously consider the award so passed as an interim order and see whether it is applicable under Section 9 for it to be applicable. So you will have to go through that hurdle, unless of course it's in the nature of an award. The Indian party can always, the foreign party can always come to India and file a Section 47, but then that means that he has to go through the full rigmarole of 48 and then go through that, which takes time.
So the Calcutta High Court has, in the Medima case, in fact, they have given this judgment with respect to even if it's a foreign-seated award, and even the foreign governing law, Section 9 is still applicable. I would actually want to ask Rajat, what are his views on
So far as I am concerned, fairly simple on the emergency award thing. Like Nitin rightly pointed out, emergency award is nothing but like an ad interim procedure. So before you have your arbitral tribunal, you get a special person appointed who will look at the ad interim necessity for your protection. Now, when the courts in India were faced with this question in the Amazon matter, the Delhi High Court decided, all right, so let's take a look at it. The applicable law, the law applicable to the arbitration is the Indian Arbitration Act. They looked at it and they said, all right, this is an order which qualifies as a Section 17(1) order. Since this qualifies as a Section 17(1) order, it is enforceable by virtue of Section 17(2). When it is not an India-seated arbitration, then similarly we will have to see how that particular order, the ad interim order or the emergency award, is treated in the law governing the arbitration in the relevant to the seat of the arbitration. So let's say Singapore, for example, which enforces an ad interim order, or which enforces, for example, the emergency award. You will go there, get it enforced. If you want to come to India to have it enforced, unfortunately the only way out is to refight it before before a court in a Section 9 proceeding. There, of course, you will have somebody, you will have a recent award where somebody's already looked at it. You will place it before the court. The chances of the court agreeing with you and quickly agreeing with you will be high.
Another question which, again, as a lawyer, we would want to raise, which side are we? So, it's whether an order passed under emergency award, though we call it as an award, would actually be a award or a order per se. The distinction being that a award is something which decides finally the rights of between the parties, while no emergency order or award would finally decide the rights of the parties. So to that extent, could it be considered an award, and therefore under section 9, as pointed out by the panelists, you can go and then enforce it. Is something which is...
I think that's from the perspective of enforcement, that's called an award, because the relief is required to be enforced in any way. But yeah, I mean, that also brings me to the important... So I will now go back to the audience basically for the questions now. But quickly, I just want to talk with Amitava and Rajat regarding, because he comes from the Maritime, that he from commercial. In Maritime, it's pretty common to consolidate arbitrations, even if it's not agreed by the parties, and even if it's not a part of the arbitration agreement. Under the LMA rules it provides, the institutions provide for it. Like MCIA has provisions for consolidation of arbitrations. But somewhere they look for the common connection with the arbitration agreement. So, Rajat, what do you think? I mean, this consolidation of arbitrations are allowed, is being done, and is it like the competence of the tribunal to do it despite parties' consent?
So, see, parties are supreme. And unfortunately, the Indian Arbitration Act does not provide for any mechanism to consolidate various disputes between two same parties. So I was coming to that. If the parties, however, agree to do it, then of course it can be done. Without the parties' consent, the arbitrator cannot do it. And construction arbitrations are a classic case because the contracts, unfortunately, in India go on for multiple years. They are meant to go on for multiple years, 3 to 5, but they go on for 10-15 years. And there are multiple rounds of disputes which emerge. From experience, I can tell you, now the parties are very prone to taking as many disputes as possible together to one single arbitral tribunal. Two reasons. One is now the fees is very high, right? And thankfully, once you hit that cap of 30 lakh, beyond that, whether the dispute is a 100 crore dispute or 500 or 5,000 crore dispute makes no difference. So parties are inclined to reduce their fee and therefore sort of consolidate as many disputes as possible and take them to one tribunal. Secondly, as a matter of public policy, it makes sense to do that because if you take it to different tribunals on similar issues or related issues can give differing opinions. And that is not good for anybody because then even though those awards may be final and the courts may not be inclined to sort of interfere under 34, but then you will have two different awards speaking different languages. It makes no sense.
That's right. So Amitava, ultimate objective is the fair and expeditious adjudication and resolution of disputes. Maritime, it's a common feature. What do you think?
It is a very common feature because in shipping we have multiple contracts up and down the line. So a particular ship is put on lease to A, who subcharters it to B, who subcharters it to C, who subcharters it to D, and all may be on similar terms, and the issue which is before the tribunal is limited to off-hire claim or a freight claim, and all will be indemnity claims down the line because whatever the one holds will be down the line. So what happens in maritime arbitration, at least in England, is the first panel chooses their three, then the second arbitration will choose one from each of those arbitrators, and you may have a panel of 4 or 5 arbitrators sitting together to deal with all the 4 contracts, because at the end of the day, whatever one is held will follow instead of having multiple arbitrations up and down the line.
That's right. Nitin, you want to share some views?
Yeah. So, party autonomy, yes, if parties agree, as Aditya pointed out. But what if parties do not agree on appointment of a particular arbitrator, and we go to section 11. Now, within the scope of section 11, whether the designated court, could we argue before under section 11 that 3 contracts with identical same parties, but just because they are 3 separate contracts, kindly consolidate and put it? Whether that would be a valid argument, and would under section 11 the court will be I would say judicious enough to take the views under public policy or something. So that's a question to be tested. The only hint I can probably give or argue is a very limited point is that Section 11 very categorically says that if the agreement does not provide for the same, then things will follow. So agreement definitely does not provide for the consolidation. So therefore, can now under Section 11 it be done? So it's just a question I am posing for you.
That's great.
From experience, I can tell you that very often when the courts put this question to the parties are very agreeable, and it's happening on a regular basis. Of course, the consent of the parties is recorded in the order.
Yeah, I mean, see, all in all, it's the arbitration agreement is your Bible for the parties. You want to put anything in there, do a lot of diligence before you prepare an arbitration agreement. But there are discretionary powers given to the tribunal as well. And then, of course, the courts are supreme. You can't do anything about it. They can do anything they want. Ultimately, it's their role. So now I just want to open the floor for questions. Anyone who has a question, kindly raise your hands, and then I'll take it one to one. It's a cliche to say that either we were too good or we were absolutely that there are no questions.
I can assure you the discussions will go on even after we are off the back and start.
I'm sure.
What I've experienced.
Most of this, I'm sure, I don't know, ChatGPT can give you answers to all these questions anyway. If you can just, I know you pretty well, but if you can just introduce yourself for the benefit of others.
My name is Asif Singh. So my question was in shipping matters because I have two shipping experts on the panel, Adani and others who are knowledgeable about it. The question was that in what kind of shipping matters cross-examination plays a critical role, because as you say LMAA does it on documents, I mean, by default. So what are essentially, is it collision claims, or if we can illustrate some of those maybe.
Usually collision claims go to court because they have a admiralty specialist who sits with the judges. But we have cross-examination mainly in cases where you're going to assess damages. So for example, if a contract has been terminated early and you need to work out 5 more months of left, how to assess what's the market rate. And I think in shipping we have more expert witnesses than anyone else. And normally even expert witnesses are done in a very formulated manner where you have 2 experts appointed. They meet, they set out what are the common agreed issues, and only on the disputed issues are they cross-examined. So that otherwise, on again, as correctly pointed by Nidhi, on issues like cargo claim, again, damages, it all comes back to damage. If it is not properly documented, luckily in shipping, most of it is all documented very properly. Starting from when it gets onto a ship till the time it's taken out, everything is documented. So it's much easier unless there is any disputed issues. And then the tribunal usually says, we will decide it, you don't worry.
Also, in one of the examples of like a tow-con contract under the BIM code, towage contract, where the surveyors are the tug and the boat, tow is being towed. Tug is the servant of the tow. But the surveyor's decision, and before you have moved out and the vessel has moved out to sea, what was the decision taken? Where the registrations were not done. Sometimes they're documented, sometimes they're not. But if they're not documented, then probably these cross-examinations are required to be taken from the surveyors to the people on shore, authorities which gave the licenses and all.
Also, like how Amitava added cargo claims and claims where, an incident has taken place on the vessel, because it is absolutely isolated from anyone who is going to, give it. If I'm not on the vessel, I'm not capable of making any statement to that. I shouldn't be there making any kind of statement to that. So that any of the incidents, and there are genuinely a lot of incidents which happen among the crew members, amongst them, against the management, etc. So all of those, including cargo claims and even criminal matters, for that matter of fact, all can come under this, and this becomes very critical to have them in person, and they can be examined very well. And that's how it can really help you to come down to the truth of the matter.
Parmi, any incidents where the cross-examination has taken place? Parmi, I was asking you. You're dealing with a lot of maritime matters, no? Parmi said. She's not? Okay, I'm sorry, I'm mistaking you for someone else then. We have some time for one last question if someone has.
Yes, I have a question to Mr. Rajat, straightway. in a cross-examination, so myself Chetan Pandya, practicing on the criminal law, to here to know some about the, but in cross-examination, normally this eye-to-eye contact with this witness in box makes a lot of difference sometimes, and sometimes you can frighten, threaten by your movement or your gestures. How do you do in this online cross-examination?
Sir, I have a very simple answer. I believe that we as humans, thoroughly underestimate our capabilities. We are a species which is not the strongest, but we rule the world. Sher hai, hathi hai, but we've tamed all. When COVID came in, it came as when we used to interact with people through a screen, it didn't make any sense at all, and the kind of connect was not the same as it is today. Today, probably our mind is now attuned to understand what the other person is saying, maybe even understand emotion through a screen. And I think there is no reason why, if we continue to do it over a period of time, we'll not be able to master it. I think for some time back there was a mention of a VR hearing, so virtual reality hearing, somebody sitting in Singapore, but you seeing that person in front of you. In fact, Mr. Narendra Modi, who comes from your state, in the last election, I think through holograms, he addressed so many rallies. I think we have to get over this thing in our head that there's certain things cannot happen. When you look at a screen, look at it the way that you ordinarily look at a person, I'm sure you'll be able to overcome that barrier. I've been able to overcome that barrier. And I come from a place where initially when COVID hit, I was somebody who wrote a white paper as part of a group of young lawyers. I'm not young any longer, but part of a group of lawyers who wrote a white paper to send it to the Chief Justice. And I was so opposed to doing cross-examination virtually that I decided to write that part of the paper myself. And I wrote and I said that cross-examination cannot happen virtually. People will be tutored, it will become a joke. But after having done it consistently over the last 3 years, I can tell you I'm probably the biggest problem that you'll find.
I have a slightly different view to what Rajat has to say. I may not deliberately want to intimidate someone if I were to consolidate your question in one word. A lot of questions, once the line of action starts in the questions, right? And I do not want to intimidate you. I am not questioning my capabilities as a lawyer while I'm questioning you. But your answers, your body language, your way of answering one question will help me even change the course of my questions. If I am stuck somewhere, or if I can make it an easier path down that road, I think it's definitely in that way it definitely helps to conduct that, even if it's online or offline. But I think it's definitely more beneficial if it's offline in that context. But then a lot also matters on the subject on which you are cross-examining. If it's something which doesn't hold the extreme relevance, importance, or it's extremely critical, I think it can be conducted. Otherwise, I would still prefer to go offline with that.
Thank you. So we have come to the end of the panel discussion, and if you have any pressing questions, we can take it to the other side. Can we take it to the other side, please? Yeah, she did. But I would insist that you take it to the other side. We're running out of time. We come back at 4 again. So all that remains for me to do is thank our panelists for their time and for these lovely discussions we've had, and thank all of you for being present here and taking out time, and also being so patient with us. Thank you very much. And, again.
Thank you so much. I would say that a bit of a unilaterally we decided to change the plan a bit and to continue with the last session, and then you can have a more relaxed tea, coffee discussions post the last session, because I've realized that I have been literally drumming people to come inside and not letting them have a proper tea, coffee or lunch. So if it's okay with everybody, we request you to kindly keep seated. We'll start with the last session and then break for tea and lunch. And thank you very much to this session. Madhvendra, you made sure that nobody slept off in the session with keeping and with asking people who were not even this in the names and saying that you're up and awake and listening to me. So thank you very much. Yes, thank you.
Our final session for the day is on an interesting topic, which is appointment of arbitrators, more disclosure or more challenges. This session will be moderated by Mr. Matthew Brown, Senior Associate at Clifford in Singapore. The panelists include Mr. Aditya Jalan, Partner at AZB and Partners, Mr. Jatin Jalundhwala, General Counsel at Adani Group, Ms. Shruti Sabharwal, Partner at Shardul, Amarchand and Mangaldas, and Mr. Devang Nanavati, Senior Advocate.
Good afternoon, everyone. It's been a fascinating day of panel sessions thus far, and so a warm welcome to the final session of the day, appointment of arbitrators, more disclosure, more challenges, question mark. I am Matthew Brown from the Clifford Chance team in Singapore. First of all, I'd like to echo the thanks to Nidhi and Madhvendra for bringing us all to Ahmedabad, my first time here at least, and organising such a great event today. On our panel, we have the far left Mr. Nanavati, Senior Advocate, a well-known figure in the legal landscape here in Ahmedabad, and I'm sure therefore needs no further introduction. We have Ms. Shruti Sabharwal, Partner from Shardul Amarchand in Delhi, specialist in commercial disputes, having acted in arbitration seated around the world, with focus on construction and infrastructure. We have Mr. Jatin Jalundhwala, General Counsel at the Adani Group, with, I believe, over 2 decades experience there, handling many of the group's major disputes. And finally, Mr. Aditya Jalan, Partner from AZB Partners in Delhi, who advises on a wide variety of commercial disputes, regulatory investigations, and arbitrations with a focus on infrastructure. If I may, I'll begin with a brief introduction to our topic and the question which is posed. Under any system of arbitration rules and arbitration laws, an arbitrator has a duty of independence and impartiality to the parties. And an arbitrator, therefore, has an associated principal duty to disclose information so as to enable the parties and the institution to determine whether they are satisfied of his or her independence and impartiality. So at the appointment stage, the main purpose of disclosure is to help parties to nominate and institutions to appoint the right arbitrators and to avoid selecting an arbitrator who could subsequently be subject to a challenge. Now, in Indian arbitration, the general duty of disclosure at the appointment stage is prescribed in section 12.5, under which a prospective arbitrator must disclose in writing any circumstances which is likely to give rise to justifiable doubts as to his independence or impartiality, with reference to the grounds stated in the 5th schedule to the Act. And in MCIA arbitration, this duty is reflected in Rule 6.2 of the MCIA rules. And of course, in international arbitrations, disclosure is commonly conducted by reference to the IBA guidelines on the conflict of interests and its well-known red, orange, and green lists. One aim of disclosure and the IBA guidelines is to reduce the frequency of challenges. After all, once an arbitrator has made a disclosure, parties will be deemed to have waived their rights to make a challenge based on the circumstances disclosed. But can it also be said that more disclosure leads to more challenges? In other words, do broad disclosure obligations simply encourage parties or their counsel to make challenges that they may not otherwise have considered? So that is the question which is posed. for our panel discussion. I very much look forward to hearing the views of my esteemed colleagues to my left. And so Shruti, if I may, I'll start with you. Is it fair to say that there is today a trend towards a higher standard of disclosure required of prospective arbitrators, and has maximum disclosure, as it were, become an inherent expectation?
Thanks, Matthew. Certainly, I feel the short answer would be yes. We certainly see a lot more emphasis, even from parties, to know what is the kind of disclosures that have come from arbitrators that are being appointed. Given the fact that we made the amendment to our law in 2016, and we're one of the few jurisdictions that actually incorporates parts of the IBA guidelines into our statute, that already set us apart. So we have legislatively incorporated, look, these are the standards, this is so that there's no confusion about what could or could not be, giving rise to justifiable doubts in that sense. And even in practice, now we do see a lot. Earlier it used to be when the Act had just gotten amended, we used to see arbitrators simply giving, it used to be a one-pager just saying, no, 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 bye-bye. But now it's changed also because the Act actually requires you to disclose things like, do you have the time to do this arbitration? And that's very important in an Indian context where a large part of our arbitrators continue to be retired judges whose books are fully packed with hearings. Sometimes it takes, 3-4 months to get a date if there's 3 retired judges sitting on the tribunal. So these are all very important considerations, certainly moving to a lot more more disclosures than lesser. Yeah.
Thank you. And Devang, if I could turn to you, what approach would you say prospective arbitrators should take when considering disclosures to make around prospective appointments? For instance, should it be all the facts and circumstances which could conceivably be considered as grounds for disqualification, or could it potentially be something more selective?
Good afternoon to you, Matthew, and to all of you. This is a grey area. So obviously you can't write a Bible of disclosures when you write, and especially this will have to be viewed from the perspective of where we are sitting today. For example, most arbitrations that originate in Gujarat, the legal community is quite close-knit. We know all of each other sometimes for more than one generation. There are relationships which may not be on paper, any relationships that need to be disclosed, but at the same time there is a lot of subtle familiarity between either the counsel and the arbitrators, or sometimes even the parties and the arbitrators. So at that stage, for example, I have seen and experienced, and yet I haven't been able to advise for a challenge because it's very difficult to establish on paper, where in a big city or outside India it may be very common to share a common apartment building, say in Bombay or somewhere else. But here, I know for a fact that an arbitrator who lived in a particular complex, and there was a counsel who lived in that complex, and we felt that there was more than that meets the eye. So that disclosure, I don't know whether it should be made as a disclosure or not. So the conceivable list is very high. The Act gives you an indicative list. And I was just talking to one of the learned judges today morning, and I said that perhaps legislature needs to put a little more effort and lay out a little more exhaustive list, and then say that if any of these disclosures were not made, then automatically the award goes. Because I'll come to later on when the challenge goes. Because the challenge of the Indian arbitration awards, domestic arbitration, lie before a district judge. And for a district judge to then sit and look at the bias of a retired High Court judge or a Supreme Court judge or a former Chief Justice of a High Court becomes very difficult. So I believe that yes, while it, as Shruti said, it might be a little lengthy, I think the disclosure list has to be a little more lengthier, a little more expansive. And if the arbitrator feels that there is a subtle relationship which may not come out on paper or may not be known, he should disclose it so that the parties then don't feel that, okay, this had we known, we would have, kind of raised our hand before. So that is, I am certainly in favor of more disclosure,
if you have a disclosure policy, then yes, more. It should be there. And but at the same time, I know as it happens in courts with matters, it's very difficult for that balancing act as to where you draw the line. But yes, more disclosures would help.
Okay, thank you. So more disclosure on what potentially a good thing. Aditya, if I could turn to you, and perhaps we should ask Nidhi and Madhvendra on the stage for this one as well. But in your experience, do arbitral institutions prefer to appoint candidates with, as it were, a perfect bill of health? So, I mean, candidates who have no disclosures or no possible basis for challenge at all. And if so, would that act as sort of a disincentive to making broad disclosures for arbitrators looking to attract appointments?
Should I just give you the mic? I think both are sitting there together. It's just easier to hand over the mic there. But simply speaking, who wouldn't? Perfect is always a utopian concept. So would I want a situation where there's a perfect bill of health? Yes, of course. The question more so is, do you expect one? Do you really get one? I don't think that is what you need when you're appointing an arbitrator. The Act and our experience shows that at the end there needs to be a justifiable basis for there to be impartiality or lack of independence. Now, I partly agree with Shruti and Mr. Nanavati that there needs to be disclosure. However, the more the disclosure, I believe each disclosure may act as a weapon in the hand of a lawyer trying to question the impartiality of an arbitrator. There needs to be a line, because I clearly believe a perfect bill of health is a utopian concept. More often than not, you're not getting one.
Thanks, Aditya. So you've sort of alluded to, perhaps a lengthy disclosure list, possibly acting as an incentive for counsel or parties to make challenges. So this sort of moves towards the ultimate question, which is posed in our panel, and perhaps I could come back to you, Shruti, on this one. I mean, as I mentioned at the start, one of the purposes of disclosure is ostensibly to avoid the risk of future disruptive challenges to the arbitration process. But can more disclosure actually have the opposite effect? And is it likely to encourage more frequent arbitrator challenges, which may or may not be meritorious?
I think I agree with Aditya to some extent, which is that more disclosures is certainly, in the right or wrong hands, going to mean more guerrilla tactics in the sense of raising challenges to appointments. Having said that, I do feel like I'd rather, as counsel, deal with that challenge in the initial stage of the appointment than deal with it in a setting aside proceeding. Because then you're really taking the risk of having your entire award vitiated and then restarting the entire dispute before a new tribunal. So if that has to be the situation, and it is the fallout of additional disclosures, but despite knowing all of this, internationally we are still moving towards even more disclosures than what we have today. The UNCITRAL recently, though in the context of investor state, has come out with draft rules, though the April rules I think are not in the public domain yet, but the January draft actually requires you to make disclosures for the past 5 years, while our Act right now says 3 years, any appointments by the same counsel, same parties, for the past 3 years, please disclose. Now we require, as per the UNCITRAL rules, we're moving to a 5-year disclosure, which necessarily means there is a lot more to actually disclose. Yes, it is going to be challenges, no doubt, but also practically may not always be the situation, because then you're really looking to potentially annoy your tribunal, because at least in my experience, most of these challenges don't get upheld. And then you have a tribunal which is probably annoyed with you, and I wouldn't want to be in that position either. So any good counsel would caution against just challenging for the sake of delaying, because you may just actually be kicking yourself in the process.
Please, yeah, go ahead.
So, I don't know whether MCI's rules, frankly, I don't know them so detailed right now on my top of my head. But the proviso to section 12, at least in Indian arbitration, seated arbitrations, provides that once you've agreed and known the disclosures and you've agreed, then you waive your right to challenge them. Therefore, as I said in my earlier part, if you have a detailed disclosure and then you have an agreement that you are waiving this, then perhaps the institution can add a rule that this will be the additional disclosures, and once you have accepted them, then you waive the challenges, unless later on a disclosure which was, or a bias which was not disclosed earlier comes up, that only remains as a ground of challenge. So it kind of addresses what Shruti was trying to say. That's what I feel in my experience has worked better.
Would you like to check in on that one, Aditya?
I think I agree with Mr. Nanavati with just a small addition. I think with more disclosure, there needs to be an understanding about fair disclosure. There needs to be an understanding that the disclosure is objective and not as subjective as possibly currently the list is. So that the arbitrators or the prospective arbitrators know what they are disclosing. As a consequence, yes, I agree that there are going to be lesser challenges later on at a stage when the award is there. However, by adding subjectivity to it, the question mark on whether this was justifiable to disclose or not still remains vague.
Thank you. Of course, it doesn't always take a successful challenge to dislodge an arbitrator. Some arbitrators would simply prefer not to be subject to nuisance challenges, however vexatious, and would simply rather retire or accuse themselves rather than having to deal with a challenge. So does the principle of more disclosure, therefore, which might sort of encourage challenges and narrow the pool of arbitrators who might otherwise be available? Aditya, if I could come back to you for that one.
Well, I believe we anyways need to look beyond our current pool. I believe at least in India where clients and lawyers stop looking at if you've not sat at a bench, that should not be the test anyways. Having said that, yes, there are going to be some arbitrators or prospective arbitrators who would say that I don't want to get into this muddle, regardless of whether it's successful or unsuccessful. My name is being thrown up and I don't want that. So there are going to be a few. But I think most would be mature enough to know and would know to hold their integrity and would want to hold their integrity. So they will take it, and if at the end of the day there is a situation of justifiable doubt of a bias. See, the question is not whether you are biased, because that stage has not come. The question is whether there's a doubt of a bias, doubt of partiality. So if the group at the end decides that there is a justifiable doubt, you step down. That's not a question on your integrity. And that's the attitude I would implore arbitrators to keep, or prospective arbitrators to keep. That if some go, that does not mean you step down, because you're giving an easy way out to the councils otherwise.
Thank you. Mr. Jatin, if I could turn to you for something of the client or the party user perspective. What's the client perspective on arbitrator disclosures? Do you like to see candidates which you are nominating make broad disclosures, or do you think that that is likely to provide the basis for arbitrator challenges?
Thank you. Yeah, first of all, let me tell you, the word disclosure has been of vital importance in today's corporate world. Better disclosure, more disclosure is considered as a good corporate governance. I am talking about arbitration. As far as Arbitration Act is concerned, you all know Section 12 has been amended in 2015 and have brought into Section 12, 13, 14 and thereafter Schedule 5, 6 and 7 as a disclosure part. And more precisely, it clearly says that you should disclose as far as possible. One of the points some people are saying a broader disclosure, but I do not agree to the word broader disclosure. I feel as a corporate and as a client side, we should have a disclosure. It should be full, fair and true. These three things we have to see. And as far as we are concerned at a group level, we have a lot of arbitrations going on. So we, and I as General Counsel, we have a checklist. When we are appointing a particular person as a arbitrator, we see what services or what advices he has given to us in last 3 years or so. And thereafter we decide whether to engage him in this arbitration or not. That's the first part. Secondly, we have to see the 7th schedule first, because you all know Section 12.5 clearly says that the list which is mentioned in the 7th schedule, then the arbitrator is not ineligible for the appointment unless both the parties expressly agreed for appointment or the other side is ready to waive the applicability. In such situation, me and my team first will see the 7th schedule and applicability of that 7th schedule to the arbitrator proposed by us. And there is no issue, then we will appoint an arbitrator. In one arbitration, what happens, one of the retired Supreme Court judge, very respectable, he has given us 2 opinions in last 3 years for the same company, but not related to the same subject. But we feel, and he also said, okay, we must disclose this fact also, so that in future nothing happens. And to show the impartiality and independence, it is required, and we decided it has to be disclosed, and we disclosed that these 2 opinions are given, say for the GST Act or for some other things, which is not related to this particular subject. So we feel that as a client, the full disclosure is required, and till date, I am telling you that since last 17 years I am working with the group, we have never seen any challenge as far as disclosure part is concerned from our opponents.
So, since I've tagged on that question, I'll just add a line to that. While what Jatin says is his experience, my experience when, not Jatin but when other corporate clients have come to me for arbitrations, it has been a painful exercise to explain to them that if there is a even a small presumption of bias or any relationship that might make you vulnerable, then you should avoid it. And in fact, even if the other side is ready to waive that, the reason, and I'll quote again an example from experience which better explains this, in an international arbitration, our client, when I was being led, that name I can disclose of my leading counsel, Mr. Darayas Kambata, whom I hold in very high respect. Most of you have probably worked with him or know him. And he was very insistent, and so was I, that you should appoint an arbitrator whose reputation is so good and who has, there is no presumption, even though the other side may waive that. For the simple reason is that only then will he be able to convince the co-arbitrators if at all your point is being accepted. Otherwise you will have a divided house and you will have to solely rely on the third arbitrator or the chairperson for seeing that whether the matter falls. And it so happened that in an ICC arbitration under Indian law, seated in London, we were able to get a rarity, that is getting the award, the arbitration out on a preliminary jurisdiction award, and it was unanimous because I think we made a great choice of an arbitrator who had absolutely no relation or any such issue of past opinions or advice, even if they would have been disclosed. And I think from that perspective, from a counsel's perspective, it is always advisable to convince the client that please go for an arbitrator who does not, even though waivable or waived, does not raise it out, because his credibility will help you on the bench, on the tribunal.
Thank you. And Mr. Jatin, I think you mentioned that you in fact rarely face challenges on the basis of your own nominated arbitrators' disclosures. What's the approach that you take to arbitrators appointed or nominated by the opposing party? Will you scour through the list of any disclosures, and are you likely to seek to make a challenge based on disclosures by your opposing arbitrator?
So an opposite party appointed arbitrator, I think it's very essential to handle with care, I must say, because challenging the impartiality of or independence of the other arbitrator, we have to be very careful. First of all, we have to see the disclosure made by them, and thereafter we'll find out as a company that anything which is left out and which is material disclosure which has not been made, in such situation we may go for the challenge of that disclosure, not disclosure. In one of my case, practically what happened in Mumbai, two arbitrators are appointed by two parties, and the umpire was appointed, and later on we found that one of the arbitrators, the umpire was a very old person of 85 years or so, and one of the arbitrators from the other side was a junior to that arbitrator. So they were in the same chamber, I can say. But in such situation also it became very difficult for us how to challenge, when to challenge. And we put our objection during the arbitration. Arbitration went on, we lost the arbitration. But thereafter in section 34, we put all these facts that this has happened, and they were two, one junior and senior, both in the same chamber, and they were arbitrators. So I feel that whenever disclosure has been made by the other side, we should be very cautious whether to challenge or not, and if it is to be challenged, when we have a concrete reason to challenge. Otherwise, we should not challenge. Thank you.
Thank you. If I could just turn to a couple of the examples of disclosable circumstances under the IBA Orange List, and also incorporated in the fifth schedule to the Indian Act, and these are this is the question of repeat appointments, either by parties or by counsel. Quite well-known requirements that if within the past 3 years an arbitrator has been appointed on more than 3 occasions by the same counsel or the same law firm, or within the past 3 years an arbitrator has been appointed on 2 or more occasions by one of the parties or an affiliate of the parties, those circumstances fall within the IBA Orange List and should be disclosable ordinarily. As a client organisation, how do you manage the issue of repeat arbitrator appointments?
Yeah, it's what you said about 3 years. So you see that Schedule 5th, which clearly says item number 22 and 24 about the disclosure part, whether a particular person, an arbitrator, either has been appointed for more than 2 years constantly in last 3 years or so. And it happens that sometimes either we ourselves would have appointed one person for 2 or 3 occasions. But what happens, there are number of companies within the group, so the subject matter may be different, and even the company may be different. So we may appoint the same arbitrator for some other work. So in such situation also, the first and foremost principle that we shall disclose, he has acted upon or he is acting as an arbitrator for these 2 matters. That's one part. And secondly, 3 years means we have to see in 2 or other matters, 2 or more matters he has been arbitrator. But if the subject matter is different and even the companies are different, I don't see any problem. In one of our arbitration, what happened? The other side appointed one arbitrator for the 3rd time in 3 years, and but they disclosed to us, and in a disclosure they said, okay, this is the person who is being appointed for the 3rd time of the same arbitration. So we immediately objected on that time, because no doubt he may be impartial independence, but we said he has been appointed for the same authority and the subject more or less the act remains the same, and therefore we request that we may have some other arbitrator. But sometimes when we go for a specialized act like Shipping Act or so, it is very difficult to get the good arbitrator, because these are all some specialized subject, and in such situation with particular clause that some arbitrations related to infrastructure projects, some related to shipping lines and other things, it needs that there are certain specialized arbitrators in such things, and they have been appointed. So 3 years criteria is definitely good, but there are certain if and but, and that we can sail through.
Thank you. Thanks. And I mean, those particular IBA guidelines are sometimes criticised because I mean they're in a lot of in law firms they're essentially treated as binding rules that that we Clifford Chance, for instance, shouldn't appoint the same arbitrator on more than 3 occasions in the past 3 years. But I mean that rule has been criticised as being overly rigid. I mean, what's your sense on those rules? Do you sometimes wish that you could, I guess, bend those particular IBA guidelines and that appointing an arbitrator more frequently shouldn't in fact be problematic?
I'll answer it.
Sure.
I mean, yeah, certainly there's, especially like Jatin said, there's some subject matters where it's actually you need a expert in that field of not even law necessarily, but industry sometimes. And those pools are normally very limited. So the moment you kick this 2 or more times situation, you're sometimes outing from the potential pool some very capable people who would remain unbiased, but just because of the fact that formally that rule is there, you end up not being able to go with them. So yes, certainly there are times that even we wish we could appoint the same person more than twice, but the clients are not happy if that goes into challenge, so we won't try it.
Just me add here also, we also have a panel of arbitrators. Panel means we keep say about 10-15 people which are either from the retired Supreme Court, retired High Court judges, depending upon the place like Bombay, Ahmedabad, Gujarat, Delhi. And similarly, we have some people who are technical experts also. So that what even in the morning we said, the arbitrator may or may not be a legal background person, maybe a technical person if the arbitration relates to more technical matter. So in such situation, we also see if one arbitrator is not appointed for more than 2 times, 3 times within 3 years or so. So that there should not be any challenge at a later point of time, and the whole process of arbitration is vitiated over a period of time. So it's very important at the first instance, if disclosure is there, and we have seen in checklist that the arbitrator is not for more than 2 arbitrations, then it will help us over future that nothing goes wrong.
I just wanted to take a contra view that apart from these guidelines and the 7th schedule and the rules, what happens at least in India, is that the government authorities, say for example ONGC or any of these central government companies, and they have their own panel of arbitrators and you have to select one from them. And when you are opposing a government company, there is a serious bias issue already there, and then you are compelled to kind of see an arbitrator come from that panel, especially when there is a provision of a sole arbitrator. And because that arbitrator is a former judge of the High Court or the Supreme Court, it becomes very difficult, and usually these appointments are made through an 11-6 order before the High Court, where your room to argue that you don't want this arbitrator is going to be very difficult in an open courtroom. This is an issue which I haven't been able to find a solution to. I don't see the reason why these corporations need to have a panel. It's not that they are paying the panel. And of course, most of them are independent. It's not that we've not had arbitrators appointed from this panel who have necessarily always held in favor of the corporations. But that is a serious issue. So this panel business in India must stop, even for government companies. I seriously feel.
So here, if you see, MCIA has already made a good rules for as far as the disclosure and other part. Rule 6, Rule 10, they make it very clear when an arbitration is to start, the arbitrator has to disclose what, and completely it has been detailed by MCIA. And I've seen as far as the institutional arbitration is concerned, in the morning also, Nidhi has said about one arbitration in Gujarat, which was MCIA governed arbitration. So whenever we go for such type of arbitration, the MCIA or such institutional, it has a reputation and versus ad hoc arbitration. And the rules which have been made by MCIA are also very clear. I've read through it, section 6, 10, because even today we are having one arbitration at MCIA.
Moving on to consider another potentially disclosable circumstance, the question of issue bias, where an arbitrator might have publicly advocated a position or written about an issue which might be a question in the prospective arbitration. What kind of situations can arise there, and what disclosures, if any, should arbitrators make in relation to those sorts of public positions that they've adopted? I'll go to you first on that one.
In my little experience that I've had in arbitrations, I've not yet faced an issue-based arbitration, because I don't think in India for domestic arbitrations we do that kind of deep research unless it's very obvious. But I know, and I'll give you an example from my personal life or professional life, that one of the first cases as a third-year law student, and then eventually even as a lawyer because the case dropped off, was the famous case which you may not know but the others may, is of the unjust enrichment case in excise duty matters. Mafatlal Industries was the lead judgment. That case was in Gujarat, handled by us, so we were in the Supreme Court and we were led by the legendary Mr. Fali Nariman. And the bench, a 9-judge bench, consisting, led by then the second senior most judge, Justice Ahmedi, just passed away, became Chief Justice. So before the matter began, Justice Ahmedi told Mr. Nariman and the Attorney General, I think it was Mr. Milan Banerjee, that my father, that is Justice Ahmedi's father, held 60 shares of Mafatlal Industries in his name, and he thought that he should disclose and asked that if you have any objections, then I would like to recuse. So naturally both counsels, Mr. Nariman and the attorney, said that no, we don't have any objection. Justice Ahmedi insisted that they put it in writing and give it, which they gave. And then Justice Ahmedi told Mr. Nariman that, all right, Mr. Nariman, you can begin. And I remember as a young law student, very impressible in my mind that a counsel could address the judges of the Supreme Court, and I could see a very, very flustered and angry Fali Nariman, very assertively, which he always was, roaring, pointing to his right side and pointing towards Justice Sawant, who was one of the members of the bench, and saying that your lordships have dealt with your objection, what about our objection? And Justice Ahmedi said, what objection now? He said, we have a problem with Mr. Justice Sawant being on the bench because he is given public speeches on unjust enrichment. After this episode, immediately Justice Ahmedi and I think it was Justice Ratnaval Pandian, the next most senior judge, who discussed something, the bench rose, reassembled 15 minutes later, Justice Sawant was replaced. So issue-based bias is certainly something that is a very serious thing. Though I must frankly admit I haven't experienced it in my professional career in arbitration. So, but if it would arise, yes, it would matter.
This reminds me one more point, what he said, that our arbitration was there and the opponent side appointed one retired Supreme Court judge for that arbitration. We know the subject, we know the law, because as far as that matter is concerned. But we found in next 15 days that the same judge has given an order, a judgment in Supreme Court of a similar type of nature. So we immediately wrote to them so that his thought process is very clear and he is going to go accordingly. And therefore we requested that this arbitrator may be replaced, and it was done.
What about personal relationships? The close personal relationships, for instance, fall under the IBA orange list. I believe they're not, in fact, in the 5th schedule, unless I'm mistaken, but I don't believe so. But I think Devang, you earlier mentioned something about sort of counsel and arbitrator living in the same building. I'm not sure if that would sort of cross the threshold of a close personal relationship, but I mean, Aditya, what's the how would you elaborate on perhaps the threshold that needs to be passed for for close personal relationships between counsel and arbitrators that should be disclosed?
So first, Matt, it's there in our 5th schedule. It's, I think, serial numbers 9 and 10, which talk about family relationships. As far as the line I believe is murky, to say the least. While it becomes easier to disclose and identify blood relationships, if I can call that, and of course, needless to say, most arbitrators, judges will recuse themselves if that issue arises. I have seen situations where counsels have recused themselves to go before the specific arbitrator or judge because of the relationship as well. The line gets murky when it's not a blood relationship. In the modern world, I don't think closeness is associated always with only whether you're father, son, brother, cousin, etc. I think the biggest question is, when do you disclose a close friendship? And the friendship could be any kind. I think Mr. Nanavati just mentioned two people living in the same society. So again, there is more to it. So do I always disclose if I have an arbitrator who's living in my society? It is better to err on the side of caution. Why? Because this is something which, again, one may say creates justifiable doubts. However, whether an arbitrator in his disclosures will give a long list of all counsels who are residing in his society, obviously not. Yes, if you have the counsel in front of you, it's a point of later disclosure. If you have a counsel who has been in the same chamber, either junior or colleague, or who you holiday with, for example, it is better to disclose that at that instance. Again, because the test here is that of justifiable doubt, and as Shruti mentioned earlier, you would rather disclose it now. If there is an objection, have the objection then, or forever hold your peace, rather than have it at a stage where the award has gone against the contesting party.
I mean, just to add to that, and I think we all agree that just being neighbors with someone certainly doesn't require a disclosure. But even then, it is a grey area, and it's also very cultural. For example, the American approach, which is a lot more purist in its approach, is that, you know, if we ate dinner together at one point in time, then that ought to have been disclosed. The European approach is a lot more like, well, this is such a small community anyway of arbitrations, that if you start disclosing absolutely everything, then you're giving the other side the opportunity to weaponize it. So, I mean, while we're still sort of coming to terms in India with what is the approach we would like to take, I think it would be fantastic to have a balance of the two. So don't feel the need to overly disclose. I mean, if you genuinely feel, put yourself in the shoes of the party, and if you would feel that, oh, that may, raise questions in the party's mind, then disclose. But don't feel obliged to disclose, inconsequential things, because then it will get weaponized. Then the standard is that, well, Aditya is my neighbor, therefore all my neighbors should be disclosed in that sense.
Perhaps a slight side issue. There's a push to encourage younger, more diverse candidates as arbitrators. A lot of those younger candidates will find themselves in large law firms where, as we know, clearing conflicts for arbitrator appointments can be challenging. So the question then arises: how can the pool of potential arbitrators widen to include younger and more diverse candidates if you're faced with that choice of choosing a career as either counsel or as an independent arbitrator? Shruti, shall I come to you first on that one?
I think certainly there is a push for younger people to sit as arbitrator now, and really the only way that's going to get done in a larger way, as in actually walking the talk, would be through institutions. And not just because this is an MCI event, but generally MCI is, for example, one of the few institutions which is known to promote, younger nominees for arbitrations. There are a few, there's a lot of institutions that will say all of this, but when it comes to actually giving the names for nominations, you will still see the same old boys club in that sense. So there's certainly a change, and when you're in a law firm, certainly, I mean, I had the issue where, the conflict because, the firm is representing one of the clients, in which case you just disclose that immediately and don't even take it on, because that's really on the side again of being safe than sorry later. So, yeah.
So one thing which possibly we speak very less about in India is career arbitrators. I believe while retired judges do make a career out of arbitration post-retirement, there are a lot of lawyers who after a point of time ought to take it up. I think I see that more in international circles where when you meet people, they introduce themselves as arbitrators. However, I don't see that in India. Even while you may do one or two off arbitrations here or there, you don't really introduce yourself as being an arbitrator. You're always a lawyer first. So when you're talking about young arbitrators, I think more and more younger people should start owning up to becoming and being an arbitrator and not just a lawyer.
So I agree with Aditya, but the problem is it's a vicious circle. I am one person who is always wanting to do more arbitrations as arbitrator, but the most, as I said, at least speaking for myself in Gujarat, most of the arbitrators are appointed under the High Court's regime, and somehow they don't seem to look beyond former judges as arbitrators. That has to change. So, of course, yes, on the council side also that mentality has to change. But introducing myself as an arbitrator, I'll go hungry. So, in a law firm that can be done, but not. I would like to reserve my 2-5 minutes that I may still have, and if she does not object, respected Harshaben is here. She is a former judge of the Gujarat High Court and one of the most busiest and sought after arbitrators in Gujarat. If on any of what we have discussed today, she would like to enlighten us with her experience or views for 2 minutes, it would be a great privilege, Harshaben. All right.
Thank you, Devan. At this point, I think we'd like to open it to the floor to see if there are any questions on this topic. Mehta, shall we go to you?
is a lot of emphasis on disclosures before the start of the arbitration. There is little guidance on what to do in terms of ongoing disclosures, right? Things may change, matters may change, views may change. As Jatin said, suddenly you found some judgment. Luckily you found it before the first hearing. What if you found it after 3-4 hearings? Or even they change the apartments and go in bigger apartment and start staying with the council. So what I'm trying to say is that do we need more guidance on ongoing disclosures? Because at the end of the day, as a claimant, you are vulnerable to an award which may not have been disclosed at the start because those have propped up later. And there is no obligation to disclose in that sense. While it says continued or whenever you get to know and things like that, but all of that applies at the start rather than ongoing. So do we need some new methods or guidance, or maybe MCIA can come up with something to bring about a change?
The AI should be replaced by AI is replaced by the judge. So I think no, because India, we are the people. We are means 130 crores. We are the number one in population. We have I think 5 crores matters are pending into the courts. I think 26% of our population. So it is not a big number. And number of judges into the India is, including Supreme Court judges, we have 7,500 judges. Total over 130 crores population. So one judge is handling all the criminal matters, all the civil matters, all the commercial matters, arbitration matter, intellectual property matters. We, as per our different acts, the number of courts are constituted, but the works allotted to a one judge. So the question of delay is a different aspect. But even otherwise, we are disposing the number of matters day and in day. So the artificial intelligence cannot be replaced, because if the data which has been, it is algorithm. As we have discussed, artificial intelligence is based on an algorithm. So we have to feed the data that if I will give the simple example, if any person may steal an apple, the conviction is 3 years. And if any person steal a number of rupees, then also the conviction under section 379 is 3 years. So it is the algorithm which has to decide whether the 3 years is suitable to a person who has steal an apple or a number of money. So I think for India, it is a human being, let the human being decide the matters. So thank you, Nidhi, for giving me the opportunity, and it's a power-packed knowledge sharing event. Thank you very much.
Thank you, ma'am. This brings us to the end of the event, and we would like to thank each and every one of you for staying till the end of the day. And we hope to see you all again next year for the 4th edition of this conference. I would now like to invite all of you for tea outside. Thank you.